Hello friends, civil service aspirants and dear listeners. My name is Nishikant Tiwari and I have been teaching for the civil services optional subject as well as for general studies, different topics for last 10 years plus. I have been interviewed for the UPSC in Dhalpur House, New Delhi in 2003 and 2004. I have done that MPhil in International Relations from Jawaharlal University, New Delhi. So in today's topic, I am going to discuss two very important constitutional doctrines that is prevalent in two great democracies, India and United States of America. That two are important, a bit confusing. So need to understand their different aspects, their rationale, their applicability, and all other different aspects. These two things are, one is that divisions of power, division of powers, right? This is called in Hindi शक्तियों का बंटवारा, or I am telling in Hindi also for the benefit of Hindi medium students. Largely I will be following that English medium, शक्तियों का बंटवारा, and the second one is separation of powers. Separation of powers. This is called शक्तियों का पृथक्करण. शक्तियों का पृथक्करण. Now, if you look at both deals with the power, right? But this is division of power. This is separation of powers. Most of the people you will find at the learning stage, they do not find difference because separation almost they consider equal to separation. But these are two important constitutional doctrines. I am discussing in today's episode the key differences between two and their application and a broad understanding of two concepts. Now look at the divisions of power. What is division of power? So this is the feature of federal government. Feature of federal government. Now you know government could be of two types. One is unitary types like we find United Kingdom or China. The other model is federal type. So what is federal type of government? Federal type of government means dual polity. It implies about dual polity. Dual polity means there will be two layers of government, right? So this is the one layer of government, that is the full country at the pan country level, and the second is the second layer of government. So this is first government 1, and this is government 2. The two layers of government you will find. This could be the union government, and this will be the state government, right? So both the government, union level and the state level, they both together constitute the dual polity, and such system is called federal system. Now in federal system, there could be conflict of issues. So what will be the jurisdictional competence? That means on what matters that federal government should look into, and on what matters that state government should look after. So I am talking jurisdictional competence is very important one, right? Jurisdictional competence. This is an important area that we need to understand. Jurisdictional competence. So what areas that this government will look after, and what other areas that this government will look after? That is one of the key aspect of federal system or the dual polity, right? So and for that judicial competence, the feature of division of power is adopted. Division of powers. And I will be talking mainly from Indian constitution point of view. So what is division of power? Division of powers means division of powers among union government and state government. Now you know in today's context there will be one union government, right? That is headed by our Prime Minister for the full India, and the state government, as of now there are 28 states in India, so we will find 28 state governments all over India. So division among union government and the state government. Now how this division has provided a scope for that scheme. So division of power in Indian Constitution is given in the 7th schedule under the Indian Constitution. 7वीं अनुसूची में ये division of powers दिया गया है, 7th schedule, and that is mentioned in Article 246 of the Indian Constitution. It provides that division of powers shall be given in the 7th schedule. Now how the 7th schedule provides for division of powers, that we will discuss now. So as per the 7th schedule, you will find there are 3 lists: list 1, list 2 and list 3, right? So division of powers which is given in the 7th schedule of the Indian Constitution, that is provided under the 3 lists. List 1 is called union list, list 2 is called state list, and list 3 is called concurrent list. That is given in the Indian Constitution, right? So what is union list, what is state list, what is the concurrent list, right? So who will make on law? So union list, that legislator, the power to make laws on the subjects provided under the union list lies exclusively with the union legislature. Union legislature, that is parliament. In short we write parliament, this is parliament. So all the subjects that is listed in the union list, that shall be legislated by the union legislature, what is called parliament. Now what is the state list? A state list, the power to legislate over the subjects enumerated in the state list is a state legislature. A state legislature, right? So all the 28 states may be bicameral or may be unicameral. They have the legislature, so they will be legislated. And for concurrent list, you will find both legislatures have power. That is union legislature can also legislate, and a state legislature can also legislate. That means they have jurisdictional competence, that is the concurrent legislative powers. So a state government can also legislate over the subjects given in the concurrent list, and then the union parliament, parliament can also legislate over the concurrent list. Now the question is, if there is any conflict over the legislation between the union legislature and the state legislature, laws made by the union legislature shall prevail over the state legislature. That is very well given. Now different types. So that is the division of power, you will find that. So under the union list, earlier total 97 subjects were given. That is in the start of commencement, during the commencement of the Constitution. Now total it has increased through the Constitution amendment, total 100 list. As of now, you will find 100 subject matter under the union list. And the parliament has exclusive power to legislate over the union list. No state government can legislate over the subjects that is given in the union list. Now over the state list, that total 66 subjects were there earlier. Now this has come down to 61. So total 61 subjects are there as of now. And similarly for concurrent list, there were as of now 52 subject matter. Now this list could be subject to amendment. It could be amended also, subject to amendment. Who can amend in this list? By parliament or by a state legislature, or both, or parliament alone? Now I would like to make it clear that the power to amend the 7th schedule, that is given under Article 246 exclusively, that is to be administered under Article 368. Article 368 provides for amendment in the Constitution of India. So what do you mean by amendment? Amendment means addition, deletion or variation. So by this Parliament could initiate Constitution Amendment Act, and it could add, or it could delete, or it could vary through this amendment. That is by special powers of both houses of Parliament. That means Lok Sabha has to pass by special powers, Raj Sabha also has to pass the special powers, and after passing by both houses of Parliament, it will go to the state legislature for ratification. State legislature may ratify it through simple majority. And once a state legislature, more than half of the states, for example today we have 28 states, so around 15 states should ratify, then it will go to the President of India, and President shall assent. President has only one option whenever a constitution amendment bill is produced before him. As per the 24th Constitution Amendment Act 1971, President shall assent Constitution Amendment Act. So in this way, a Constitution Amendment Act could be brought to amend the 7th schedule. So 7th schedule is division of power. So this is the way division of power is given. And there is one more provision, that is called residuary list. Residuary powers. Residuary powers means what? If any subject which is not exclusively given or provided either in the list 1, that is the union list, or under the list 2, that is the state list, or the state list 3, or the list 3, that is the concurrent list, then that power shall come under the residuary powers. That means it is not exclusively mentioned under the Constitution, but that may arise in future. That power shall exclusively lies with the Parliament. So Parliament will make a law under this residuary power that is given under Article 248 of the Indian Constitution. Now that's the scheme of federal structure in the government. You will find with significant modification in the United States of America. America represents the classical model of federalism. India is also a fundamentally a federal structure, but it has not adopted the American model. Rather, it is a union of states model, which is more nearer to Canadian system. So that is the actually division of powers given in the Constitution. Now look at what Supreme Court of India has to say about the division of power. The Supreme Court of India, in a famous Keswanand Bharti versus the state of Kerala in 1973, has ruled that division of power is a basic feature of the Constitution. This is very, very important thing to understand. Basic feature. What do you mean by basic feature? We know that the Parliament, along with the states for certain constitutional provisions, is competent to amend the Constitution. But the Supreme Court in Keswanand Bharti case in 1973 ruled that certain provisions of the Constitution cannot be amended even by the constituent power of Parliament under 368. That means basic feature which constitute core of the Constitution of the India cannot be amended by the Parliament, and such amendment, if done, shall be declared null and void ab initio. So Supreme Court in that case, Keswanand Bharti itself has ruled in 1973 that division of power, यानी शक्तियों का जो बंटवारा है वो संविधान का मौलिक ढांचा है. That is the basic feature of the Constitution which cannot be amended by the Parliament. So it is very, very important decision, and that what? Division of power among the list 1, list 2, list 3. And division among whom? Among two legislatures, union legislature and the state legislature. And we know that this is subject to amendment. So that is what? Division of power. That is one aspect of constitutional doctrine which is found in all the federal structure. Now look at what is this separation of power. So whether division of power is same to the separation of power, division or separation, this is sometimes confusing for some students, but I need to clear it that what is that one. This is separation of power is the also core of constitutional doctrine, core of constitutionalism. So let's understand what is separation of power and separation among whom. You know that government has three organs. Any government, be it American government or the Australian government or the Canadian government or the Indian government, government has three essential functions. One is that law making. Some organ has to make the law. Law is important for the good of the people, for the welfare, for the development, for international relations, for domestic, regulation. Law is required. So law making is one function of the government. The second, so law is made, so he is going to implement that law. There has to be other dedicated structure, so for law implementation or law execution. Right, so somebody should implement the law, enforce the law, execute the law. So law execution. And the third, while executing the law, while implementing the law, or while making the law, there could be conflict, there could be issues need to be adjudicated. So law adjudication, that is the third function. Some organ, so these are the three functions. Right? So this is the function. First function is law making. So कोई कानून बनाएगा, एक बॉडी, लॉ मेकिंग एक फंक्शन है. The second one is law execution. So law को लागू करना है. And the third one is law adjudication. न्याय निर्णयन. Justice is to be brought. Somebody's fundamental rights violated. So there should be this function also. Now who is going to make the law making work? So law making lies with the legislature. Legislature is mandated to make the law. जो legislature होगा वो कानून को बनाएगा. Then law execution comes under the domain of executives, right? And the law adjudication comes under the domain of judiciary. Now three functions and three specialized structure. This is called functional structural understanding of the constitutionalism. So what separation of power, which is given by the very famous Montesquieu in the earlier times, that was given, Montesquieu, he gave this theory. Montesquieu, he gave this theory that legislature is to law making, legislature is to make the law, executive is to implement the law, judiciary is to adjudicate law or protect the rights of the people. Now it will do law making, it will do law implementation, or it will adjudicate. So separation of power means independent functioning of each organ. Independent functioning. That means legislature will do this role only. Executive will do law execution, and the judiciary will adjudicate conflict issues or the right protection, etc. No organ is going to interfere in others' matter. So that is basically non-interference, a general theory. Non-interference. Nobody is going to interfere in others' domain. So that is the independent functioning of three organs of the government: legislature, executive, and the judiciary. That is the separation.